You want it? We have it. The hottest mortgage and real estate strategy broadcast in the nation. A Smarter Way Home with your host, Danielle Boote and Victor Bals. 50 years combined experience, ranked in the top 1% in the nation for home loan originations 2020. Promise to expand your knowledge, utilizing creative mortgage financing and home buying strategies. Build a bridge for a better quality of life. Get your brain cells firing for a smarter way home. And welcome to another episode of A Smarter Way Home. Modern mortgage solutions and home buying solutions for real estate professionals and consumers alike. My name is Victor Bals, loan officer for over 22 years now. And I am the host, and I want to introduce my hostess with the mostest, the loan officer extraordinaire, Mrs. Danielle Boote. How are we?
I'm fabulous today, Vic. How are you?
I am pretty good.
He's got a lot of energy in the
morning.
morning.
Well, hey, it's lunchtime to me.
I know.
I was up at 3:30 this morning. But today, as we talk about modern mortgage solutions and home buying strategies, one of the things that come up is elder law and trust, a very important part of everybody's life. And Danielle, why don't you introduce our guests and give us a little bit of some golden nuggets here, what we're going to get into.
It is my pleasure to introduce Erika McNamara with McNamara Law in Brighton, Michigan. She is a estate planning attorney and has been in the Brighton area for well over 10 years. She is very involved in our community, the local chambers of commerce, charity organizations throughout the county as well. She can give us some more details about that, but she's a wealth of information, and we get a lot of questions being in the mortgage and real estate world from buyers and sellers about titles. And it's interesting sometimes how much a customer will share with us. Well, what do I do about this? I want to put my child on the title. I want to do this afterwards. And inevitably, we're going to refer them to an estate planning attorney because they're big questions and mistakes can be made with your real estate. The other thing that is really important, another question that we get frequently as well, what do I do if, for instance, you may have a sole person buying a house. What about their spouse, significant other? How do they protect them? What do they do with the mortgage? And a lot of times people are not legally married, which is another potential complication. So we thought we would dive into that today. The other thing, and Vic and I have both gone through a lot of stuff personally the last few years. We have both lost parents or several parents and have lived through, as an adult child, the passing of a parent. And we have found firsthand the importance of paperwork, legally, powers of attorney, medical power of attorney, all of those things, trusts, wills, and there's a lot. It's a lot to think about. We were just talking before we started recording. Nobody jumps out of bed in the morning and goes, I'm going to do my will or trust today. And boy, am I excited about that.
Right. I'm excited about it. How about that? I love my job. That's the best part of my practice is the estate planning, and I can talk about it all day long. And you're right. People don't wake up and think, oh, I'm going to get sick or I'm going to die today. I prefer them to wake up and say, you know what, I'm going to protect my family today. I'm going to protect myself, because really these documents that we're talking about today, a will, those durable power of attorney, and the trust documents or a deed, or however you're going to get all of those to work together, are not just protecting you, it's for your family, it's for your loved ones. And just as you said, if only one person is on the deed and you pass away, then we have a court issue, right? And we call that probate. It's a fancy lawyer word for taking stuff to court after you die.
Okay, well, and as we dig into this, so let's take our listeners and say they do not have a will or a trust. One, why do I need a will? Why do I need a trust? Why do I need estate planning? Let's take it right back to the beginning of why someone may want to start having that dialogue at an earlier age.
Because if you do nothing now, then the state of Michigan will decide where your assets go after you die.
So me as a homeowner, maybe even I'm renting or whatever, me as let's say a married individual, wake up one day and say, hey, I'm going to get a will or a trust. What do I do and why do I need it if I don't have a lot of assets?
You need it, again, to make sure that the people that you want to have your stuff after you die gets it, number one. And it's also cost effective, because if you have these things in place, you don't have to come and see an attorney for the most part, again, because everything is already spelled out.
Okay.
Go ahead.
Okay. My parents say, get a will. You need a will, right? What's the difference between a will and a trust?
So a will is that document that only works after you die. And it has to be probated. So after you die, I have to take it over. And if you're in Livingston County, I take it over to Howell, give it to the court, and they look at it and make sure that it's a good document. And it's public, meaning I can go over there to the Howell probate window and request anybody's will that has probated or taken their will there since the beginning of Livingston County.
Oh my goodness, I didn't realize that.
Yes, if you want to have a fun day, we can just go and pick out some people's names, and they'll give it to you. You can sit right there. You can read exactly who they gave things to and who they cut out. I have seen documents before that have said, I am purposely leaving my son out of this, and he knows why.
Yeah.
So a will is only good after you die. It has to go to the court, and it's public. If we add a trust to that, because that's the second part to your question, it's a private document, and it works during your lifetime and after your lifetime. So I would make a little tiny will and add to it a companion trust, which is a very long document that spells out everything that could maybe possibly happen, and we don't have to go to court. It's private, and everything can be managed for you if you become incapacitated and after your death as well.
So you could hire a trustee.
You could hire a trustee.
If the estate was large enough and it needed to be.
That's right. That's right. And I think, there's a lot of misconception about trusts because we think of those big time people from the 1900s, right? The Rockefellers, the Vanderbilts, these people had trusts. And so that's kind of what's in our brains. But really,
Yeah, we don't have that kind of money.
we don't have that kind of money.
But the working man.
The working man now is in the trust area because it's become more in vogue for people that are the working man, just because it's a very nice vehicle, if you will, to manage your assets during your lifetime.
Okay. Cool question. And I did not know the difference, but when you create a trust, there's a revocable trust and an irrevocable trust. Could you explain that as we start out?
Sure. So when you make a trust, it's revocable. So you're making it and you're putting things in it and you're going along your way. And
So I'm making a trust. I'm alive.
Yes, you're alive.
I'm granting my children stuff once I die and my spouse. It's revocable, meaning I can make changes to it.
Yes, you can amend it, you can add to it, you can subtract from it, you can do anything that you like.
And upon my death,
Upon your death, it becomes irrevocable.
irrevocable. It's in stone.
That's when it becomes in stone. Now, there are those trusts that I can make that are irrevocable from the start, and that has a lot to do with Medicaid planning and that kind of thing. And there's all different kinds of trusts, actually. It just depends on what you want to do. Sometimes, we live here in Michigan, and people have those properties up north that they want to make sure, I want this to stay in my family, for all time. Well, I can make you a cottage trust. And these kinds of cottage trusts can spell out exactly how the property will pass to those next generations, how things will be paid for. So that's a good way to preserve that up north property as well. If someone in your family has a disability, sometimes autistic children or children with Down syndrome, to plan ahead, I can make them a special needs trust. And if they're getting benefits from the government, This kind of trust will ensure that any monies that come to them in the future won't kick them off of those government benefits.
Because of income.
Because of income. So
Yeah.
there's many different kinds of trusts. It just really depends on you and your family and how you want to plan.
One question that you guys just briefly touched on about a will, that somebody dies and they have 3 children, and they specifically don't spell out one of the siblings in there. I heard it was a good rule to always leave that one child $1, so you made an acknowledgement that you had that child and you didn't forget about that child.
That is true-ish.
Okay.
That used
Well,
to
give me
be-
the ish part.
That used to be the way, but now there's certain language, legal language, that has to be included in the will. If you're going to omit one of your children, then you can, because it's your stuff. You can do what you want with your stuff. But there's 2 certain paragraphs just off the top of my head right now that have to be included in that document. And that's why you come to a professional. You know, you're not going to just write it yourself.
Right.
To make sure that your wishes happen.
Well, one of the things that I learned from you a few years back was that the Michigan state law has changed.
It always changes.
It always changes. So we had the conversation that, look, even if you had a valid will and a trust, right, it had to be updated. So as an example, and I'll recite what I recall here, you could make a will. You could, years ago, you could say, okay, this is who's my family member. This is going to be the trustee of my estate or whatever. This is going to be the guardian for my children. And they never had to acknowledge, correct?
That's correct.
And then in the past, I don't know, few years, the state of Michigan said, wait a minute, that makes no sense. So, you know, someone needs to acknowledge if you're making them an executor of the will or, for instance, a guardian to a minor child. I mean, it's a pretty huge responsibility. So if you have older documents, maybe explain how they need to be updated to make sure that they're valid with the current state of Michigan laws.
Well, there's 2 parts to that question, Danielle. First, yes, it is true that the law did change, and you do need an acknowledgement from the people that you're naming as your agent, your advocate, your trustee, or your executor. But the second part is that why are your documents not in the right place in the first place? Because something should have been triggered. You know, those durable power of attorney documents should be with your bank, should be with your financial planner, should be with your tax preparer. Just because if something happens to you, and if they have it on file, then they would contact you when that law would have changed. And I find that people don't file these documents in the right places. The documents are sitting on your bookshelf or in a file someplace. And really, these documents need to be in place now. And that includes the trust as well. You know, you have to alert your bank that you have a trust. You don't want to be waiting until you've passed away and your next trustee is showing up saying, oh, I got this trust. And the bank's like, oh, well, that's great. We don't know anything about it, right? And we're trying to set up a trust account and do all of these things. If that trust had been in place once you executed it, then the bank would have alerted you, oh, hey, you know what? A little bit of change, just have them sign this and it'll be fine. But now, if it's not in the right place, we're playing catch up to something that you've already done.
You know, it's funny because I am the trustee or executor on 3 different trusts, not by want, you know, but by default. And what I've learned having my personal living trust is you need to update it every year because you get new bank accounts, banks switch over, 401ks may be switching over. You may have bought or sold real estate. And I've just come to know that that's part of my living, I guess, life maintenance of my estate is to always be in contact with my trust attorney to make sure everything is updated and make any specific changes.
And I have clients that haven't looked at it or updated it in 30 years. And I always think in my head, wow, your life just must be magic because nothing has happened. Nothing good has happened and nothing bad has happened. You know, good is adding people to your family. adding assets to your life. And of course, bad is, people passing away or divorce or those kinds of things.
Well, the thing that I think gets difficult as people age, and those of us that are in the age group that we have aging parents, as they get older and slow down in life, they're not going to remember. Where was that paperwork? Do I have the power of attorney? Do I not have the power of attorney? And my father-in-law recently passed away. And even though we had all the paperwork in place, it was still a lot of work. And you're a family member that's dealing with the grief of losing a loved one, no matter what their age. And now you've got to deal with the banking, the Social Security, pension stuff. I mean, and even if they don't have a lot of assets, that is still a huge undertaking. And you're dealing with grieving, right? And planning a funeral. And now you've got to deal with all this other stuff too. And if you wait too long with an aging parent, they may not be at the capacity to make those decisions. Unfortunately, with our population living longer, we're seeing more Alzheimer's and more dementia.
Yes.
And it creeps up on you. Vic lived through this too. It creeps up on you and you don't know. And you might not even know when your parent is diagnosed, because you're not going to the doctor's appointment because you think that they're okay. And then unfortunately, 3 to 5 years later, as things progress, you go, wait a minute. We had a diagnosis 5 years ago that we didn't know about. And you go, wow. And I'm not going to get into personal stuff, but you could then go back and look at certain behaviors and go, well, this wasn't logical when this was done or that was done. And, I've heard stories from, I had a gal that I worked with years ago whose dad lived with her, and she was he was in his 90s, and very sweet elderly man, but he would literally write a check for $1 to donate to charity because he thought that was a lot of money.
Yeah.
And he, I don't know what his financial position was, but he lived with his daughter and her husband. They were caring for him. And it got so bad, the daughter took the checkbook away because he would write he would sit at the kitchen table and he'd write 25 checks a day for $1. Yeah. And when he started giving to charity that way, she said the mail was insane because it was like these charities knew. So you go, in his heart, he was doing a good thing, but she was like, wait a minute, this is getting out of hand. It was just this one little thing. And I don't know that he had dementia or not, but you just go, oh, wow. You got to be careful with things.
You do. And he might not have had dementia. Maybe he was just doing what he thought was the best thing to do. Right. And he'd always done it. And that's how we're going to do things now. And that's just not how we do it, right? We have Venmo and all these other, everything is done digitally.
So let's talk a little bit about the power of attorney situation and how important that is in today's world. Regardless of if you have a spouse or not, you have to have a medical power of attorney on file with your medical facility.
So when your parent does all of a sudden end up in the hospital, and then that goes with the HIPAA laws.
That's right.
Yep.
Okay. So those, Michigan has 2 durable power of attorney. One is for financial matters and for the personal care of the person, and the other one is for medical decisions. And the medical decisions could be end-of-life decisions, or those could be just, minor operation things. We all have procedures done, and we can't make decisions if we're under anesthesia. And that's why we have that in place, so that a person that we believe is responsible enough to make those medical decisions for us can do that if we can't. And, that durable power of attorney for financial matters and asset matters, which includes real estate. One of the first words on the durable power of attorney that I make for people is real property. Manage my real property. So this means that if something happens to me in the middle of a sale, or I want my house to be sold or whatever, and I'm incapacitated, the person that I'm choosing to be my agent, a responsible individual, can manage that for me while I'm incapacitated.
That's funny you mentioned that, because I've had my trust for several years, and I had started my trust, and then I started having conversations with my parents because they were asking questions about it, and they said, hey, maybe that's a good idea for us. So it became a conversation at the dinner table, and then I would talk to my parents, and then as they did get a trust, and my parents started to get older, my mom had my wife, because my dad was taking money out of the bank, and he was putting cash in the house, because he was scared of the whole financial thing's going to blow up and that. And so my mom had given my wife Maya the checkbook and said, hey, we want you to take care of all the bills. So we had a durable power of attorney drawn up. Right. And as a couple of years went by, we started to see my dad fall, get worse with dementia, and it started coming on. And then we decided, you know what, maybe you ought to give me healthcare power of attorney too. So it was kind of a growing thing, but it was no pain at all, because we were having these conversations through the years, and they trusted our attorney, and we just said, this is good. And then ultimately that worked out to, I guess, the siblings' benefit, because I had to pull the plug on both my parents and take care of all the finances of the estates. So when they had died, there was no probate court, and the trust was completed in 6 weeks. Yes. Mm-hmm. It was very quick there, and I'd kept my siblings up to date on the trust as well. And I tell you, I wouldn't live without it. I would never advise not having that vehicle, that tool.
Well, and let's talk about some war stories. I guess you were sharing.
We got war stories.
We're coming off of the COVID pandemic.
Yes, we are.
We have lost a lot of friends and family members, and even if it wasn't COVID related, we have seen. Cancer is still out there, and cancer does not discriminate on your age.
No, it doesn't.
So if you are listening and you're in your 20s or 30s or 40s or 50s, this conversation is for you. It's not just for old people that are retired, right. Or the older population. And, one of my daughter's best friends was killed April 2nd in a car accident on 96 and Wixom Road.
28 years old?
28 years old.
Yeah.
Yep.
She was single. Mm-hmm. She was in the Michigan National Guard, and I wouldn't have thought about a 28-year-old having a will, right? She was single. She didn't own a house. She had a car. She had a job and some assets. Well, because she was a member of the full military, and she was actually on her way to the Howell Armory. Mm-hmm. The military requires that service members have a will.
Mm-hmm. Right.
Okay.
Yeah, well, because that's their job.
Right? Their job is very risky,
yes.
right? And she was on her way to Kuwait, and unfortunately was killed in a kind of, let's call it a freak car accident.
Mm-hmm. Yeah, and it happens, right? Again, we're not waking up in the morning thinking I'm going to get into an accident. Or
no, she was going she was going to deploy, right? I mean, were we worried about her? Sure. We're like, oh my gosh, she's going to be in Kuwait for a year. Now we're going to worry for a year until she comes home. And I have other family members that are in the military too. But you go 28 years old, but she had a will. Mm-hmm. So it spelled out what to do with her assets and things of that nature. And you go,
well, I think that's a good point that you made, that we're coming off this pandemic. And what we learned, hopefully, one of the things we learned is anyone can get sick. Mm-hmm. Anyone can die. It doesn't discriminate, as you said, and it doesn't matter. And at least being a little proactive with having some documents in place would alleviate issues for your family, because again, it's for your family. It's not just for you. And as I was saying before we got started, I've had 4 clients who are my age, in their middle 40s. They have passed away due to complications from COVID, and they had nothing in place. And unfortunately, they were the breadwinner of their family, and now we have a probate situation, and now all the bank accounts are locked up. Now the house is unsellable.
Because it was a will, and it's locked up in probate.
And they had nothing in place. They did no documents at all. No. So now we fall back to Michigan statute, and the state of Michigan is going to decide who gets their things. And that's a problem, because if, you're unmarried and you're living with your significant other, the significant other is not in the line under the law in Michigan to receive your assets. That person's family is. So the children, if there are children, or parents of that person, or then the siblings. The significant other, they're out.
Yeah.
However, correct me if I'm wrong, once it goes to probate, that significant other could contest that and throw a wrench into the fire or log into the fire there.
Yes, they could show up and say, I've been living here and,
She told me that she was going to give me everything.
Yes, but one of the only kinds of things that has to be written down still, we've got those deeds, they have to be written down. A will must be written down. That's from old English law, and that's why it has to be written down. And speaking it doesn't mean that it happens.
Okay.
Well, and there's even complications. Look at the amount of remarriages that we see. So I had a client in the last couple of years who had a good career and a good income, and she remarried. Okay. So it was, I don't know if it was her remarriage, but it was he had a previous marriage and adult children. They were older. Okay. They were not young kids, right? Kids were all grown. New wife moves into the husband's house. They were together for, I think, at least 10 years. Okay. She stopped working. He retired. She was just enjoying life with her husband. He passed away suddenly. She thought she was entitled to the home, and she wasn't. I don't know if he ever updated the will. She truly knew nothing about her husband's financial situation or estate situation. And now there's adult children.
Right.
So there was a ton of stress, assets locked up.
Yes.
And she ended up having to sell the marital home, what she needed to do because it was obviously too large for her.
Was the ex-wife in the will?
No,
Oh,
I don't.
okay.
I don't think the ex was in the will. But basically, the way it was written is that the adult children got half the estate.
Right.
And maybe that was the way he wanted it, but she had no idea what was going on. And I went, ooh, that was challenging. We then had to literally rebuild this woman's life, and now she's in her early 50s. She wasn't, she's not that old, and she's going to have to go back out to work and rebuild her career. And it was, I don't know what the whole thought process was, but it was very complicated.
So wait a minute. Where is that will? Let's talk about that. So, okay, the guy dies, and all of a sudden, what happens? Who shows this will? Do the kids have a copy of it? Is it recorded? Where is a will generally kept?
In my experience, on the bookshelf in my clients' homes.
Yeah.
So someone may not know that there's a will
They
out
may
there.
not
They
even
start.
know.
It goes to probate.
Or could somebody have an old will? Like the
someone
kids could have had an old will,
Yes.
not realize dad updated it, and does that pop up
That
in
can
the
pop
mix of
up, and
things?
then the later will is the one that controls.
Whoa,
See
hold
how
on.
exciting
Let's
this
go
is,
down
right?
this rabbit
People
hole.
think my job
Sounds
is
like a
boring.
soap opera.
So let's just take that. Let's take Danielle's example. So that gentleman dies, and let's say there's no will. Everything goes to probate, and now the new wife, by cleaning out the house because she has to sell it a year later, finds this will, and the estate's already been split. What happens in that situation?
That's complicated.
Hey, man, that's my job.
I feel like I'm taking the bar exam.
Oh, yeah.
Again. I guess she could come forward and say, look, I just found this. It wasn't supposed to be split this way. And then we'll have a big court case. Yeah.
But, okay, so they find a will, but if it wasn't recorded, how do they know that he actually signed it? Does it have to go in front of someone?
Yeah, it's signed in the state of Michigan. You have to sign, and you have to have two witnesses.
Two witnesses. Okay.
Yes.
Okay.
And sometimes even a notary will notarize as well.
And that's a legal document.
Then that's a legal document. It's a contract, really. We make contracts between parties. This is a kind of contract that you're making with yourself.
Okay. And in that will, if you have a living trust, that will becomes part of that living trust.
Yes.
Which now the living trust controls
The trust.
everything.
Yes, the trust controls.
Yeah.
Yes.
Very interesting.
Well, I've heard stories from you over the years. There was a famous person, Prince Prince died and had no will.
Prince died and had no will. Aretha Franklin died and had no will. All of
I heard they
these-
found the will in her sofa.
Well, maybe not. I mean,
Okay.
all of these people pass away. Kincaid, the painter, he wrote on a piece of paper what his will was supposed to be, and he signed it. It's a good will, right? You can handwrite your own will and date it and sign it. It's a good will.
But you got no
if
witnesses.
somebody finds it.
If somebody finds it.
But if there's no witnesses,
And that's okay, because in Michigan, that's called a holographic will.
Okay.
So you can handwrite it yourself, right? Right.
Wow,
If
okay.
we find a regular typewritten will, and then we find this other will, and so then we have a will contest. And many times famous people don't do this either.
Isn't that just insane that they feel so immortal? They have, Prince, think about the money that Prince had or his estate had.
Yes.
That's millions and millions.
that's
and
got to
millions
be
of
still
dollars.
tied up.
I'm sure it is, but I think that's bad lawyering as well. They don't have good advice. If I was I wish I was Princess.
Not now.
But I would have,
Yeah.
really pushed and pushed and pushed to get him to write something down. People don't think that they're going to die. That's the whole thing, right?
Well,
They really don't.
Danielle and I have been doing mortgages forever, and we always preach to our clients that your mortgage is a vehicle to create wealth. You have to nurture it, look at it, change it around during market conditions, such as a living trust is just as important as that home ownership and that mortgage.
Well, let's dive into some of the questions that we get from
Okay.
clients that are buying houses.
Okay.
It is not uncommon for somebody to buy a house. One party buys the house. They could have a spouse or a significant other. And then they say, well, how do I make sure my significant other gets the house if something happens to me? And that's a loaded question, in my opinion. From a mortgage world, we cannot add a borrower onto the loan after it closes. Nothing can change with the mortgage. You can't take people off. For instance, in the case of a divorce, you cannot add people on in case of a marriage or something of that nature. Right. But people will play with the title. So let's chat about that a little bit. I'd love to get your input.
Yeah.
That is very tangled.
People play with deeds all of the time, and I never understand why people are writing their own deeds. I really don't, because there's huge implications for changing the names on deeds. There's tax consequences, there's liability issues, and I think that people don't understand that. Danielle, if you and I are owning a piece of property together and you want to put me onto the deed, right? We're not related. We're not in a relationship. And what would happen is, the taxes uncap, right? And so the tax assessor is going to come out and reassess your taxes because we're not related, and we're not in a relationship, we're not married, and those kinds of things. But it also is a tax consequence because you've just given me $100,000 in assets. So you've given it away. You've given $100,000 away in assets. It's also a liability issue because if I get into an accident and somebody sues me, that piece of property is now in my asset basket for that person who's suing me.
Okay, hold on. So you guys are not in a relationship. We quit claim deed you onto Danielle's title. You end up in legal litigation, get sued for some reason, and because that is recorded with the township, you now have an asset that potential person suing you could come after that property.
Yes. While
Danielle's alive.
Yes. Everything that you just said is true. And the thing that usually happens is a parent puts a child, right? That's what we're talking about here. Puts a child onto their deed as the full owner. And a lot of times that child could be in arrears for child support. So child support is going to get attached. They're going to put a lien onto that property if the deed has their name on it because that's their asset, even though the mom or the dad is still the owner.
Okay.
Well, one of the things that has changed in the mortgage world in the last 15 years is that every lender is going to do a public record data search on every borrower. So years ago, we would never have known that, Mr. and Mrs. Jones put Bobby Jones on their title to their home, okay, as an estate planning tool in their mind. But now we're going to find out about it. And as a lender, we're going to say, Bobby, do you own that cottage up north? I need to see the mortgage papers and I need to know what the taxes and insurance are, because we're going to count that as your liability, even if it's a third. And Bobby goes, well, that's my mom and dad's house. Well, then why are you on it? Right. It is complicated. I have had buyers that come to me and say, I'm a first-time home buyer and I want to take advantage of a special program that's out there. They are disqualified as a first-time home buyer if they're on a deed to a property.
Right, because
we don't care if they live there or not. They're an owner.
Wouldn't a ladybird deed help in that case?
Why, yes. Yes,
Right.
it would, because a ladybird deed is the nice way of saying transfer on death. And the ladybird deed is a property that perhaps Danielle owns during her lifetime. And she says, you know what, Erika, I want you to have this after I die. And we write this deed where Danielle is still the owner. She still can sell it. She can mortgage it. She can rent it. She can do whatever she wants to do with it during her lifetime. But once she passes away, then I take Danielle's death certificate over there to the Register of Deeds, and the property is mine, and it automatically passes to me. But this also is a substitute to a will or a trust, right? Because it does avoid the probate process. So that's another reason why you would want to come and talk to an estate professional, because maybe you don't need a trust, right? We kind of touched on that a little bit when we got started. Not everybody needs that. It just really depends on the individual and what it is they want to do in planning.
Okay, let's go back to that situation where someone was suing you because Danielle deeded you onto the property. So now, if there was a ladybird deed, right?
Yes.
Danielle puts you on with a ladybird deed. Only upon her death you get that house, but I sued you. Okay. Do I have access to that property upon her death?
No, because I'm not the owner until Danielle
Okay.
dies.
And the second question is let's say she deeds you onto the property. You're both living. I'm suing you. Would it be wise to have tenants in common?
Oh, well, tenants in common is a way to hold property in the state of Michigan. Tenants in common allows the individual, after they die, to will it to the next person.
To their half of their property.
Half. So my half wouldn't go to Danielle. She would own it with my best friend, who I put in the will.
Or the guy who sued you.
Or the guy who sued me.
Okay.
That's right.
Interesting.
Yeah.
Tangled web.
Right?
there.
Oh, the web we weave.
Yeah. Wow.
So, yes, again, that's a very good point, right? When we're making deeds, we have to make sure, how are we owning this property? And this is also something that perhaps our clients aren't thinking about,
Right.
When they're making those deeds.
Well, or when they're making those emotional decisions, like buying a home or something like that. How does it all play?
I had a client just in the last couple of years buy his first house, single man, and he put his girlfriend on the title after he closed.
We see that all the time, common.
Right. They broke up in less than a year, okay? She moves out, moves on with her life. And then in the last 2 years, we've seen a massive interest rate drop. So the young man contacts me to refinance.
Oh, God.
So we start the file. I didn't ask any questions. Did you change title? This is a single guy, right? I didn't occur to me that he would have done this. Well, it turns out he puts his girlfriend on title. Now he has got to track her down to try to get her to sign the deed.
Right, to sign off saying that she doesn't want it.
She's holding him hostage on that.
Apparently, they did not split amicably.
Oh.
And she was going to hold him hostage for $10,000 for something. She never made a payment. She didn't put $1 into the purchase or the maintenance or the upkeep of that home. But she was not happy with this young man. He learned a very big lesson.
So did you turn it into a cash out refinance?
I don't remember. I think somebody got involved. I think the realtor The original realtor was a friend of the family, so there had to be several people that got involved to get her to sign off. I do believe we closed them, but it was a huge mess.
Yes, because she was the owner of the property.
Yes,
By putting your name on that deed, you're the owner, right?
Yeah, I had another transaction last year where a young man buys a house with his girlfriend, rural development, zero down, and they broke up before we closed. And nobody said anything. So they were fighting, the 30 days were processing the mortgage and getting it ready to close. They're imploding.
Yeah.
He never said anything to me or the realtor. They close. And then he literally was calling a month later going, how do I refinance and get her off the mortgage? And he was afraid he wouldn't qualify. And he qualified fine on his own. I was like, oh my God, I wish he would have said something, I mean, there's just a lot of legal implications there.
Yes.
Well, what I'm seeing here is this conversation, because we're supposed to be talking about living trust and estate planning, of how important every real estate transaction it needs to be discussed with an elder law. Well, this is estate planning attorney to say, here's where we're going. How do we get there? How do we protect ourselves?
Right. Yes.
Wow.
And your job, as people in the real estate business is huge. It's the person's biggest asset.
Yes.
And they're making silly decisions or quick decisions and not thinking
uninformed
decisions for their biggest asset, probably the biggest asset of their lives. Some people will stay in their houses for 40 years and they're not, thinking through.
Well, we had I heard of a story recently where you talk about the up north family cottage. Yeah. Okay. So a father bought a large parcel of land in northern Michigan, built his cottage. As his children got older, he built additional accessory dwellings on the property for each of the children. Right. So now you have a very large tract of land that has 4 or 5 houses on the property. Right. Dad passes away with the intent to leave the estate to the kids. Right. Well, guess what? Out of those 5 children that were left behind, one of them could even afford it.
That's right.
So now you have a property, and everybody thinks about, the family cottage, right? Every house needs a roof, has going to have maintenance issues, plumbing issues. It's going to need to be maintained. So at the time of the patriarch of the family's death, most of the siblings were not in a financial position to take care of the property.
Or probably even visit either.
Correct.
Right? They're
Correct.
not visiting.
So one sibling who was obviously more successful in life decided to buy all of his siblings out of the estate, of the parcel of land, and he's able to keep it, preserve it, maintain it, and does allow his siblings to use it when they can to preserve the dad's wishes. But you go, okay, that would have been a great situation for the dad to have a cottage trust, and he should have funded it, because everybody looks at property going, I want that property because it's worth X amount of money. But nobody thinks about the taxes, the upkeep, right, and things of that nature. Or how about, guess what? If dad dies, that property's going on homestead.
Right.
Okay?
That's right.
So now the taxes are probably going to double, and then you have all the other issues, and you go, okay, it's great to think that this is an asset, but property, even if it's free and clear, is a liability.
Yes. Yes, that's a very good point. It is a liability.
Yeah.
For many different reasons.
Yes. And then you're going to end up with this huge family disaster, right? And a property that, and let's be honest, with properties up north, they're not always easy to sell.
No, and they're not easy to get to. And you have to make that idea in your head. I'm going to drive there and stay there and do that.
They sell well when the economy is good, but when the economy is bad, that's the first thing that shuts down in the state.
Yes.
And now talking about that particular instance, for instance, let's say the father had quitclaim deeded all the siblings on, or they had a stake in that, and that home went into foreclosure. That foreclosure now goes on everybody's record, and that will kill you for getting a house. Now,
even if it's not on your credit report.
Right, even if it's not on your credit report. So in that case, talking to an estate planner and keeping them updated on what's going on, you would advise I'm assuming, well, you can prepare the quitclaim deed off that because I want no part of that estate.
Right.
Now, here's a question. Let's say I am on my father's house. I am deeded on my father's house.
Okay.
He let the house go to foreclosure, okay, because he lived in Florida, right? Yeah. Lived in Florida, and he let the house go to foreclosure. Can I, after the fact, after his death, quitclaim deed off of that so it's not on my record as a foreclosure?
No, you're on there. If you're the owner, you're the owner. Whoever's, on the tax roll, you are the person responsible for that piece of property from the day that you put your name on it until it's sold or foreclosed or whatever happens with the property.
And if it was in a family trust, right, and I was going to be, my part of the inheritance was to gain that house. If it went into foreclosure, as long as I'm not on title, I am clean. If I am on title.
Correct. What you just said is correct because it's inside that trust. You're not the true owner. The trust is the true owner. Is there some responsibilities there? Yes, but you're not being held to the same level if it's only your individual name.
Okay. Another question that keeps going here. Now, we talked about updating the trust regularly. We talked about having children getting older. My daughter's 24 years old right now. And because we have had a trust for several years, we've had many conversations at the dinner table. And my children it's kind of part of their natural thing where, mom and dad are talking about the trust, and we have those conversations. And, I had my brother-in-law, and he's 60, 62, getting older now. And now we're at the point of saying, you know what, my daughter's coming of age. She's 24. She's pretty bright, where we actually switched the hierarchy of the executors. And we moved her up to number 1 position. We moved my son to number 2 position. And we moved my brother-in-law in the number 3 position because he would always be there if they had a question. And my children are comfortable about that. So to me, it's a family operation because it's not about me. It's about me being a father, taking care of my wife and children after I'm gone. So I don't create headaches for them.
Right.
Yes. They're going to have, you know what, this is not a pleasant topic, right? You don't want to.
I like it.
Yeah. Well, but
I get your.
It makes when you're thinking of it that way, Vic, it makes you feel good.
Absolutely.
That you are taking the leadership role in your family to make sure that your wife is provided for, your family is taken care of, and on that horrible day when you're no longer here, to know that they can deal with grieving.
Right.
And everything else is going to fall into place instead of dealing with a huge disaster. And I think that generationally, you talking about that or me talking about it with my adult children, so they understand, and I own a lot of real estate, and I have talked to my adult children about it because I understand that, heaven forbid, if something happens to me at a younger age, my kids are going to have to deal with this, and they need to be a part of it so that they understand it can be dealt with. It's not going to be scary, and here's how I'm going to lay this out. If, God forbid, something ever happens.
I want to bring up one point because, my daughter and son brought up, well, Dad, if you die, what do I do? It's a trust. And I go, the first thing you do is you call the estate attorney, then you call the financial planner, and then you call our accountant in that order. Yep. And they will take care of everything because they've all got copies of the trust.
That's right.
Yep.
Yes.
But it's just going to make they're going to respect me once I die and everything goes smoothly.
But hopefully having those discussions today with this younger generation will help them also be prepared and live more proactively instead of burying your head in the sand like Prince and go, because who knows? You can't even imagine. Could you, Vic, look back to be in your 20s? Come on.
I would love to be that, but no.
But
how stupid was I?
But could you imagine that you ever would have gotten where you are today 30-some years later?
No, I not at all.
You can't even imagine. Jim and I celebrated our 31st anniversary last night, and we were sitting there talking at dinner going, my gosh, I couldn't have even imagined where we would be today. And it's not about money. It's not about property, but you can't even, you go out and build a life, whether you're single, whether you're married, whatever your vocation is in life, you go out and build it. And when you're young, you kind of can't imagine. And there's good things that happen. There's bad things that happen along the way, but you do get some peace of mind with the paperwork.
When I look to my 20s, I look back now and say, God, what I so naive.
Yeah.
But as I started to learn the dynamics of a mortgage, an estate planning, elder law, and you learn how to navigate through all those things, it makes you much wiser. And I think it actually added to my success because I'm actually being able to correlate between different things. It just makes you think differently.
It does.
And it's about protecting, because I learned when I was young that I don't need an attorney. I'm not going to pay for an attorney. This seems easy. That's a waste of money. And every time I made a decision, there was some loophole where I was found wrong because of the law.
That's right.
And that's why I got these gray hairs. So I've got my college education the hard way.
On the street. Yeah.
Right.
So let's talk a little bit. Over 35% of buyers in this country right now are first-time home buyers.
Okay.
The average age of the first-time home buyer is 31 to 33 years old. Okay. The millennial generation is huge, 45 million of them, bigger than the baby boomers. If we are taking that generation, what should we say to them and say, okay, here's what we want you to think about, and when should you take these steps along the way in life to protect your property, your assets, and your family?
If you have children and you have this big asset, your real property, right? I think the other thing to consider is just what Vic just said, is he was doing things when he was younger on his own, and I'm sure that's what the millennials are going to do. Well, I can do all of that online. I can get a will online. I can make a trust online. That's great, because at least they're thinking. From my point of view as a practitioner in this area of law, great. You're thinking about it, and if you get it from online, also great. But there's probably something wrong with it, and then that's
to their unique situation.
And then that's the time, if you want to take that document to an attorney for them to review to make sure that it's right. I do that all of the time, and any attorney would do that as well and correct the document for them. So, you're asking me, when is the time? The time is when you have children or you have this big piece of property. Now, I'm excluding myself, right? I'm not married and I don't have children, but I also have parents and I have a sister and I have a family. So just because I don't have those things in my life, that doesn't mean I don't have people in my life that I want to protect. Right. So,
well, for instance, if you're a single person buying a house, and that is going to go up in value in the next couple of years, if you do not create a will, okay, and leave that potentially even to your parents,
right?
What's going to happen to the equity? Okay, so if young person passes away, 35 years old, they own a house and it's got $50,000 worth of equity in it, and there's a mortgage on the property. So if they stop paying the mortgage upon that family member's death,
then if it's extinguished, right? Because we're not responsible right now in the United States to pay the bills of our loved ones, right? We're not responsible to pay someone's debt after they pass away. So it would be extinguished, in the house, in this case.
Would go back to the bank.
Would go back to the bank, back to the state of Michigan, or however it would work.
So that, potentially you would think that a person that passed, their family's not going to know who the mortgage holder is, which means the family's not going to be able to keep up the mortgage payment to try to protect the property, to get it through probate to then potentially sell it. Right. So all of that equity in that home is going to be lost to the state because you didn't have a will.
Because you didn't think ahead of time.
Okay, question on that. Okay, so that 33-year-old person buys a home, and let's say he did have a will, and he willed it to me, and I don't want it because he was underwater. The value was there. Because something is willed to me, do I have to take it, or I can tell the court, no, I don't want that obligation?
No, it's a gift, right? So all of these things that we receive in probate or from a trust is considered a gift under the law. And as you know, you don't have to accept my gift if I give you something that you don't want.
Okay. Because I got, this has got me a little concerned here, and it's almost like, is once someone gets a mortgage, it should almost be mandatory that they have some education on trust and estates and how to set up protections, in a sense.
We need to do a class on this.
We need to do a class.
We should do.
We're doing a class.
We should do a class. Yeah, Erika, we're gonna we'll have this conversation afterwards, but we should do an estate planning event at the office.
At the minimum, we give them a link to this podcast.
Yeah,
to say, hey, before you close, you better listen to this.
Well, one of the questions that I get frequently from, again, that young first-time homebuyer is, I'm buying a house, my wife is young and she doesn't work, and I have a child. How do I protect them? And this would be a discussion, for instance, about life insurance. So there is a product out there called mortgage life insurance that most homeowners are going to get solicited on through the mail. So what happens when you close on a mortgage is that the deed and the mortgage are recorded with the county, become public record, and the county will sell that information, or someone can go and purchase that information from the county and say, oh, Bobby Jones just bought a house in Howell. Now I'm going to mail him information about mortgage life. Well, it is a life insurance policy with a declining policy amount. So if the mortgage was for $200,000, you get this life insurance for $200,000. As you pay the mortgage down, the life insurance benefit only will cover the remaining balance. Right. Okay. Typically, what I would recommend my clients to do is talk to an insurance agent that will sell you a life insurance policy for the life of the loan. So if you have a $200,000 mortgage, go get a $200,000 minimal life insurance policy and cover the mortgage, cover the life policy for 30 years, which is the life of the mortgage. If you are young and in good health and hopefully a non-smoker, those policies are not expensive. And that way, if something happens to the primary wage earner, the additional spouse and children are covered. And then the wife could potentially, or the husband, whomever, could pay off the mortgage and just have to keep up with taxes and insurance. Right. But obviously they need more probably than that.
They probably do. Yep. And if they do nothing from this scenario, if they don't purchase this mortgage insurance, there's actually a federal act in place that John McCain put in place a long time ago that protects the widow or widower. So if there is a mortgage, as long as the mortgage continues to be paid, they cannot be put out of the house. Now, they don't have to refinance and they don't have to be put out of the house. But that's just good public policy, right? Because we don't want all of these widowers and children homeless.
Well, and there's some work with that because I have seen that happen. So if you're the spouse that's left behind and you're not on the mortgage, now you have to contact the mortgage company, provide the death certificate, provide any other legal documents so that they'll even give you access to that. Right. And in this day and age, another really important thing is online passwords. Everything is online. How many accounts do we not get statements in the mail?
That's right.
So if your significant other, spouse, family members do not have a legacy plan to your electronic data and passwords, it's going to be very difficult for them to even gain access. You know, if Mr. Jones passed away at 35 years old and he was a single man and his, even if his parents are going to take care of the property and potentially sell it and keep the mortgage up until they can get through everything, how do they even know? They won't.
They won't.
They
You're
won't
right.
know.
Right. So
that's another rabbit hole there.
That's something that's part of the questions that I ask my clients when they first come to see me. I say, do you have everything online?
Yeah.
The answer is yes. And I say, you need to start writing all this stuff down. And they
Right.
look at me, well, that's a huge task. And I said, do you think it's a huge task for you? Imagine if you're not here.
Right.
What kind of task it's going to be for the person to try and figure that out.
Yeah.
Well, let me ask you a question here, because people are always going to ask, well, what's this going to cost me, right? Can you give a range to start a living trust and or a will? What are people up against here?
So, as Danielle knows, and she's known me a long time, I meet with people for free all of the time because I think, just as we've been talking this last hour, is you don't know what you don't know. And part of my job, I think, is to inform people to make good decisions, because I don't want to be cleaning up for them later on.
So
I
they
want-
may not need a trust, they may not need a will. You're
That's
going to
right.
advise for free, and then as their unique situation, then you would consult on.
Yeah, and the average cost is $2,000, $3,000. It really, and
That's
I'm gonna
negligible.
say the favorite lawyer thing. It depends, right?
Right,
It
right.
really depends, and I am happy to assist people to figure things out. And I'm not a person who, at least in my business model, the way that I run my law practice is I'm not somebody that's going to give you a fee every time you call me on the phone. I don't think that's fair. And that doesn't encourage people to call me, right? If I'm going to, give you a fee, then you're never going to call me and you're going to make decisions that you shouldn't be making.
Well, speaking of calling you, as we're going to wrap up the show, anybody that shows any interest, what is the best way to get a hold of you? Do you have a website and a phone number that you could give our audience?
Sure, they can. My phone number is 734-476-0739. And my email, that's another good way to get in touch with me. It's ErikaMcNamaraLaw
And do you have a website at all?
I just have a page. Yes,
Okay.
they can go and check me out there. You can find me on Facebook. That's usually how people find me, believe it or not.
Any closing words for our audience, those words of encouragement?
I would say be proactive, and I think that we've been saying that this whole time, and I know it's not a happy topic, but it's something that we all have to face, right? It's not that we're going to cheat it at some point. If you're just a little proactive, you can save yourself a big headache in the end.
It's not about taking care of yourself, it's about taking care of the ones around you.
Yes, that's right.
Any closing words, Danielle?
Thank you so much for joining us, Erika,
Thank
today. It's
you.
great to see you. It's such an important topic, and I hopefully you will be very busy in the years to come with this young generation, and hopefully, but I think we will take you up. Let's plan that seminar because I think it's a great topic, and if we can get out to our local community and share some information, we will follow up with that real soon.
Perfect.
Okay, well, thank you, Erika. That's my co-host, Mrs. Danielle Boote. I am Victor Bals, and it was a great show, and we will see you next time here on A Smarter Way Home.